you had an opportunity to review your advice of rights form with your attorney?
We discussed it.
Mr. Howard, can you hear me? You and your attorney reviewed your advice of rights, is that correct? All right, and he answered all your questions to your satisfaction, is that true? All right. Mr. Howard, this is an arraignment. At an arraignment, I inform you of the allegations, and I say allegations because they are not proven facts. I determine your next court appearance. I determine whether or not you require the assistance of an attorney, and I set bond. I'm going to tell you right now, sir, it is my intention to enter a not guilty plea for you. Further, it is my intention to appoint an attorney to represent you. So at all future hearings, there will be an attorney to answer your questions and to protect your rights. Now, Mr. Halpern, your client, having been appraised of his rights, is he prepared for an arraignment?
He is, Your Honor, and I advised him before we went on the record two things. One is right to remain silent. The fact that this is a recorded proceeding and there was media present, so I've cautioned him to be very alert but quiet. He's in a very highly emotional state right now. He's very nervous, very scared. And so I also indicated to him that he will have another attorney going forward, and we'll get into the details of this case and the defenses that may be raised going forward. But today's purpose was strictly to advise of his rights, advise of the charges, and to set a bond. And so he's ready to proceed for those kind of issues.
All right, thank you. All right, Mr. Howard, this is case 236863. This is an amended complaint and warrant. It says, People of the State of Michigan versus Harris Andrew Howard. The date of the offense is on or about February 14th, 2020, in the city of Ferndale. Count 1 is a new count. Count 1 alleges that you did with intent to kill or to do great bodily harm or to act in wanton and willful disregard of the likelihood that the natural tendency of said act would cause death or great bodily harm, kill, and murder one Mary Claire Lackamp, that's L-A-C-K-A-M-P. Said act committed without premeditation or deliberation. These actions are contrary to MCL 750.317. Sir, this is a felony. This is punishable by incarceration of up to life or any term of years. DNA sampling is to be taken upon arrest. Consecutive sentence may be imposed under MCL 769.36 if each death that resulted from operating the vehicle or vessel, ORV, snowmobile, aircraft, or locomotive. This is commonly called homicide, murder in the second degree. Further, the assistant prosecuting attorney is placing the court on notice that this incident resulted in personal injury, property damage, and death. Sir, do you understand the allegation? All right, the court is entering a not guilty plea for you, sir. Count 2 alleges that you, being the driver of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Kevin Jerome, a police officer who was in uniform, and the officer's vehicle was identified as an official police vehicle, acting in the lawful performance of his duty, directing the defendant to bring his motor vehicle to a stop, did willfully fail to obey such direction by increasing the speed of the motor vehicle or by attempting to flee or elude the officer, and the violation resulted in the death of another person, to wit, Mary Claire Lackamp. These actions are contrary to MCL 257.602 sub A sub 5. Sir, this is a felony. This is punishable by incarceration of up to 15 years and or $10,000 fine. The Secretary of State is to revoke your operator's or chauffeur's license pursuant to MCL 257.303. A defendant may be convicted for each death arising out of the same transaction, and the court may order consecutive sentence under MCL 769.36. This is commonly called police officer fleeing the first degree of the Motor Vehicle Code. Do you understand that allegation, sir? Mr. Howard, I'm going to stop you before you say something that may incriminate yourself. Mr. Halpern, your client. Do you wish to discuss this with your client?
Your Honor, I've explained to him what the charges were.
Okay.
And I think he doesn't understand why he's charged as opposed to what he's charged with.
All right, Mr. Howard, these are merely allegations. These are not, in fact, proven facts. Mr. Howard, again, I'm going to stop you. Sir, I'm afraid that you may say something that could be used against you in a court of law. I'm merely arraigning you on the charges. I'm appointing an attorney to represent you. You can discuss your case in particulars as to what defenses you may or may not have. But for this point in time, we are not debating the charges. We're not trying the matter. I'm merely informing you of the charges or allegations, whichever word you prefer. All right, sir. Now, count 3 alleges that you, being the driver of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Kevin Jerome, a police officer who was in uniform, and the officer's vehicle being identified as an official police vehicle, acting in a lawful performance of his duty, directing the defendant to bring his motor vehicle to a stop, did willfully fail to obey that direction by increasing the speed of the motor vehicle or by attempting to flee or elude the officer, and the violation resulted in serious bodily injury to Mr. Robert Weed, contrary to MCL 257.602 sub A sub 4. Sir, this is a felony. This is punishable by incarceration of up to 10 years and or $5,000 fine. The Secretary of State must revoke the operator's or chauffeur's license pursuant to MCL 257.303. This is commonly called police officer fleeing second degree of the Motor Vehicle Code. Do you understand that allegation, sir? All right, Mr. Howard. The court is entering a not guilty plea to all 3 accounts. Your next court appearance is called a probable cause conference. This will be a meeting between you and your attorney and the assistant prosecuting attorney to see if there's a way to resolve this matter. Sir, I'm giving you the next available date. This will be February 27th at 1 p.m. In the event that you do not resolve it at that meeting, you are then entitled to have a preliminary examination. I'm giving you the next available date for that. That'll be March 5th at 2 p.m. Mr. Howard, as I mentioned earlier, the court is approving court-appointed counsel. You have been given or will be given a request for court-appointed counsel by the jail. Please fill it out so we can forward that to the Oakland County Circuit Court. Sir, the last issue here is bond. It's my responsibility to set bond. Bond is not meant to be a punishment. It's meant to ensure your appearance in court, and it's meant to protect society. In aiding me in meeting my responsibility, I have a report and recommendation prepared by the Pretrial Service Department. I've had an opportunity to review this. Based on Michigan Court Rules 6.106 sub B sub 1, you can be denied bond. Pretrial service is not recommending a personal bond due to the nature of the allegations and prior history. They view that you are a danger to society and a danger of flight. Lieutenant, do you wish to address the court?
Yes, Your Honor. We do have two areas of concern in regards to Mr. Howard. One is that he would be a flight risk. He has a criminal history and police contacts that span back to 2010 over 4 states. He currently has a full extradition warrant out of Texas for a bond violation on a drug charge. We believe him to be only temporarily in Michigan as he was in a rental car and he was staying at an Airbnb. Our second concern would be that he's a danger to the community. Initially, when it was arraigned, we had several passengers in the vehicle that had minor injuries and serious injuries. But as you know, Your Honor, this has turned into a homicide case. We do believe he's a danger to society. We've asked they have no bond.
All right, thank you. Counsel.
Thank you. I had a chance to go through the pretrial services report recommendation and attempted to verify what they verified. And my client does indicate that he does live in Michigan, that he's got a stable address. It's the address that's listed in the City of Oak Park. Is his intent to remain in the state? He recognizes that there are serious charges. He indicated that he has every intention of coming to court to address them. The court is so inclined. I would ask the court to set a bond that would include a GPS tether. I don't know what the family is able to afford. I know it's $250,000 was set on the other charges. I would ask the court to just include this charge along with the condition of a tether.
All right, thank you. Mr. Howard, having listened to all parties, making an evaluation based on your age, based on your lack of contact or family in the area. The court noted prior convictions from Florida, Texas, Pennsylvania. It's my understanding you were unable to give a Michigan address when you were originally arrested. Based on a lack of contacts, based on the seriousness of the charges, this is a homicide charge. The court finds under Michigan Court Rule 6.106 B sub 1, the court may deny pretrial release of the defendant charged with murder or treason. Based on that, and based on the great likelihood that you would not return, especially with your age and lack of employment, the court is going to hold you without bond. I don't believe any other conditions are required. Good luck, sir.
Thank you.
Thank you, Mr. Halpern. Lieutenant, thank you. Thank you, Glenda. I forgot to go get you, but I had all these moving parts.